Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Judgment?
Still awaited, Your Lordship.
Since the relevant judgment is still awaited from the Calcutta High Court, let the matter appear a further 4 weeks hence.
Item number 2.
May it please your lordships.
Yes, madam.
I appear for the petitioner's lordship.
Yes.
Lordship would recall that on the last date, I am making 3 separate and specific claims in my writ. The first is that complaint case number 1 of 2019 will be governed by the Principal Lokayukta Act as it stood in 2019.
Yes.
And therein the procedural safeguards have not been met. And I relied specifically on section 23 and 20 subsection 7 of the Lokayukta
Madam,
Act.
there's an order which has been passed by the order dated 23rd of May 2023.
Lordship, there is an order of your lordships dated 12th June 23.
Just a second.
Wherein.
Just a second. Yes, madam.
And the very last paragraph, Lordships have protected me. The order reads that the investigation will continue in terms of the order impugned without prejudice to the rights and contentions of the petitioner herein. However, if the need arises to arrest the petitioner, such arrest may not be made without leave of this court. Subsequent to that, Lordship, I was served with a notice of summons on 23rd June, and I've been summoned on 28th July by the special court in the same matter. My contentions, Lordship, my submission is that
Madam, all the points that you urge, you can take it before that court. That court is in season of the matter. You can take it before Lordship, that court, and we will leave you free to urge whatever grounds are available to you. We will dispose of this present petition, and if you're unsatisfied with that order, you can take steps in accordance with law. Now that Lordship, the process has been rolled out, we don't want to, Lordship, interfere midstream.
If I may, Lordships, one of my challenges to the amendment itself, and that is squarely the remit of a constitutional court. I am challenging the amendment of 2021. I am also challenging the constitutionality of the proceedings. And therefore, I am before your Lordships. And I can show that, I can make that good.
Yes,
from the scheme of the act.
Yes, let us see. Give us the act.
So if Lordships will have the Principal Act first, which is at page 60 of my writ petition.
Page 60?
60, Lordship. At page 60 is the Principal Act, Lordship, of 27th March 2014.
Yes.
And Lordship will have page 61 and the first line itself, which says the Meghalaya Lokayukta Act, an act to provide for the establishment of a body of Lokayukta for the state of Meghalaya. And then, Lordships, the definition clauses 2B, which defines bench. Bench means a bench of the Lokayukta. 2C, chairperson, means the chairperson of the Lokayukta. And then 2H on the following page, judicial member means a judicial member of the Lokayukta appointed as such. And 2J, Lordships, Lokayukta means
where is the judicial member? Where is the judicial member?
2H on page 62.
Yes.
2H, judicial member means a judicial member of the Lokayukta appointed as such.
Yes.
And then 2J, Lordships, Lokayukta means the body established under Section 3.
Yes.
My submission is that the Lokayukta together refers to a body comprising the chairperson, judicial members, and other members. On the following page now, Lordship, establishment of the Lokayukta, Section 3(1).
Yes.
As soon as after the commencement of this Act, there shall be established by notification in the Official Gazette a body to be called the Lokayukta. The Lokayukta shall consist of a chairperson who is or has been a Chief Justice of the High Court or a Judge of the High Court, or an eminent person who fulfills the eligibility specified in Clause B of subsection 3, and such number of members not exceeding 4, out of whom 50% shall be judicial members. Then again on the following page, Lordship, Section 4 deals with the appointment of chairperson or members on recommendation of a selection committee. The chairperson and members shall be appointed by the governor after obtaining the recommendations of a selection committee consisting of the Chief Minister, the Speaker, Leader of the Opposition, Chief Justice of the High Court of Meghalaya, an eminent person nominated by the governor. Now, Section 3, subsection 3 is relevant, Lordships. It says that the selection committee shall, for the purposes of selecting the chairperson and members of the Lokayukta, and for preparing a panel of persons to be considered for appointment as such, constitute a search committee consisting of at least 5 persons of standing and having special knowledge and expertise in the matters relating to anti-corruption policy, public administration, vigilance, policy making, etc. The proviso, Lordship, says, provided that not less than 50% of the members of the search committee shall be from amongst the persons belonging to the scheduled castes, the scheduled tribes, and other backward classes and women. So the selection committee itself is supposed to be diverse, Lordship, which then implies that there should be some diversity in the Lokayukta itself. And provided further that at the commencement of this Act, the search committee may submit a panel of names twice the number of chairperson and members of Lokayukta for consideration by the selection committee, and subsequently thrice the number of vacancies to be filled up. Lordship, my submission is that none of this process has ever been done from 2014 till the amendment of 2021. And I shall come to the amendments in a moment. But neither was the selection committee ever constituted, nor were these lists ever made. And the Lokayukta, the body of the Lokayukta has only been functioning with only the chairperson as member. And therefore then, on the following page is Section 5, which says that the governor shall take, or cause to be taken, all necessary steps for the appointment of a new chairperson and members at least 3 months before the expiry of the term of such chairperson or member, as the case may be, in accordance with the procedure laid down in this Act. And now, Lordship, the substantive sections, the procedural safeguards, which I was referring to, are at Section 20 onwards. If I may take Lordships to Section 20. At page 73, Lordships. It reads, procedure in respect of preliminary inquiry and investigation, at page 73. Section 20, Lordships. The Lokayukta shall, on receipt of a complaint, first decide whether to proceed in the matter or close the same, and if the Lokayukta decides to proceed further, it shall order the preliminary inquiry against any public servant by its inquiry wing or any agency, including any special investigation agency, to ascertain whether there exists a prima facie case for proceeding in the matter. 22 is pertinent, Lordship. It says, during the preliminary inquiry referred to in subsection 1, the inquiry wing or any agency shall conduct a preliminary inquiry, and on the basis of material information and documents collected, seek the comments on the allegations made in the complaint from the public servant and competent authority, and after obtaining the comments of the concerned public servant and competent authority, submit within 60 days from the date of receipt of the reference a report to the Lokayukta. So there's a right of hearing here, Lordships. And then 23 says, a bench consisting of not less than 3 members of the Lokayukta shall consider every report received under subsection 2 from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendations to proceed with one or more of the following actions. So again here, Lordship, it's incumbent that there be a bench of not less than 3 members, and that I be heard a second time. And there has to be a judicial finding that one of the 3 actions described is in order. The first is investigation by any agency, B is initiation of departmental proceedings, and 3 is closure of the proceedings against the public servant. And then again, Lordships, in 20 subsection 7, I'm again given the right, a bench consisting of not less than 3 members of the Lokayukta shall consider every report received by it under subsection 6 from any investigation agency, including any special agency, and may decide as to file charge sheet or closure report before the special court against the public servant. My first submission, Lordship, is that because these appointments were never made, this particular section 20 has never been complied with. And this criminal complaint...
Let us see the amendment.
Lordships, before that, if I may just show Lordship section 21 as well, which is pertinent to my specific case, because I was only joined later on. 21 at page 75 reads, if at any stage of the proceeding, the Lokayukta considers it necessary to inquire into the conduct of any person other than the accused, or B, is of the opinion that the reputation of any person other than an accused is likely to be prejudicially affected by the preliminary inquiry, the Lokayukta shall give to that person a reasonable opportunity of being heard in the preliminary inquiry and to produce evidence in his defense consistent with the principles of natural justice. Lordships, if I may, in the facts of this case, I'm a civil servant. I was a secretary attached to the executive committee, and my name first propped up only on 22nd April 2023, although the case pertains to 2019. And at that point of time, under section 21, I had a right to be heard, which was not complied with. The first notice that I received, Lordship, is at page 56, and that notice was under section 22. On the following page, Lordship, and section 22 pertains to statements of witnesses. If I may read section 22, Lordship. Subject to the provisions of this Act, for the purpose of any preliminary inquiry or investigation, the Lokayukta or the investigating authority, as the case may be, may require any public servant or any other person who in its opinion is able to furnish information or produce documents relevant to such preliminary inquiry or investigation to furnish any such information or produce any such document. And if Lordship will see page 56, I received a notice under section 22. And then on the following date, page 56, Lordship, is the first notice of 14th March 23 under section 22. I immediately responded to the notice And then on the following page, Lordship, page 57, my name has appeared for the first time at serial number 13 as an accused.
Where is your response?
My response is not, I went and I gave a statement which is not on record, Lordship. I responded to the 14th March notice immediately. My statement was given, which is not on record. And on 18th May, for the first time, at serial number 13, my name comes up, without being heard under section 21. And this order itself is again by a bench strength of one person, Lordship, as opposed to section 27.
Yes.
Lordship, I must show Lordship's two amendments now. The first amendment is of 20th March 2019 at page 95. This amendment was in place on the date of the complaint, Lordship. Page 95, Lordship, is the first amendment. And the relevant section is at page 96, section 2 of the Amendment Act. In the Meghalaya Lokayukta Act, after the existing section 5, a new proviso shall be inserted, namely, provided that no decision of the Lokayukta shall be invalidated due to the vacancy created due to non-availability or non-appointment of the chairperson or members. It was our case, Lordship, that this is only a proviso to section 5 of the Principal Act. If Lordship wants to refer back to section 5, that is at page 66, which talks about the selection committee and the lists that have to be made. And together with that, the governor shall take or cause to be taken all necessary steps for the appointment of a new chairperson and members at least 3 months before the expiry of the term of such chairperson or members, as the case may be, in accordance with the procedure laid down in this Act. At the time, Lordship, writs were filed before this Honourable Court, saying that since the procedures under Section 3 and Section 4 were never complied with, Section 5 is not applicable, and the proviso to Section 5 is not applicable in this case. In any case, Section 20, there's no non-obstante clause, so Section 20 rights are not covered by the Section 5 proviso. After that, the state conceded this point and came out with a further amendment of 2021, which is at page 92 and 93, and that is the amendment that I'm now challenging. 92 and 93, Lordships. This is the amendment of 26th March 2021. And Lordship, here the scheme of the Act itself has been changed, where now the new amendment says that the Lokayukta will comprise of only one chairperson or only one member. Section 2 of the Amendment Act says, in clause A of subsection 2, after the semicolon, the word "and" shall be substituted by the word "or," to read that the Lokayukta would either be the chairperson or a member. If Lordship sees section 2, subsection 5 at page 93, notwithstanding anything contained in the provisions of this Act or any other law for the time being in force, the Lokayukta shall be deemed to be constituted upon the appointment of a chairperson or a member. And it is my case now that this is manifestly arbitrary, Lordships, because the whole scheme of the Act has been changed, and rights that had been crystallized have now been withdrawn. So this is the summary of my submissions, Lordship. And if I may show Lordship one last section before I close, which is section 50 of the Principal Act at page 89. Section 50 at page 89, Lordship. Protection of action taken in good faith by a public servant. No suit, prosecution, or other legal proceedings under this Act shall lie against any public servant in respect of anything which is done in good faith or intended to be done in the discharge of his official functions or in the exercise of his powers. So it is my submission, Lordship, that the amendment itself is ultra-vires. It's manifestly arbitrary and ultra-vires.
Ultra-vires is what? Ultra-vires is what?
Article 14, Lordship. Article 14, because
Thank you.
it's manifest.
Thank you.
I'm obliged, Lordship.
This petition is in desperation and is somewhat akin to the devil citing the scriptures. Paragraph. A frivolous challenge has been made to the pending acts of 2019 and 2021, by which the original provisions of the Meghalaya Lokayukta Act 2014 have been substantially altered. Full stop. In essence, what has been done by the impugned part of the amending acts is to have the body called Lokayukta, originally intended to be headed by a chairperson and consisting of several other members, to be complete upon the chairperson being appointed. Full stop. The grievance of the petitioner is that the two amendments are completely arbitrary, ultra-vires Article 14 of the Constitution, and have taken away rights that may have accrued to the petitioner in the interregnum. Full stop. None of the contentions holds any water. Full stop. Paragraph. The Act of 2014 was not passed under any constitutional provision, nor does it refer to any other statute or material in such regard. Full stop. Lokayukta Acts have been enacted in several states to check the functioning of public servants and take speedy action where some form of wrongdoing is discovered. Full stop. A preliminary investigation is conducted to look into the credibility of the charges brought and, if the preliminary investigation reveals some prima facie basis, a regular investigation is required to be conducted, whether by a special investigation team or by the regular machinery. Full stop. In terms of the Act, opportunities are afforded to an accused or against any other person that the Lokayukta may decide to proceed at several stages, particularly at the time of adjudication. Full stop. Paragraph. There is also a provision in section 50 of the Act that protects a public servant against complaints brought against him when he has acted in good faith in discharging the duties of his office. Full stop. Paragraph. The petitioner claims that the original complaint was not directed against the petitioner, but following a preliminary inquiry, a notice was issued to the petitioner on
14th March.
March 14, 2023, to which the petitioner responded orally by attending the office of the Lokayukta. Stop. The immediate challenge herein is to the propriety of an order dated May 18, 1993, May 18, 2023, by which the Lokayukta has required charge sheets to be filed under section 7 and 12 of the Prevention of Corruption Act 1988, inter alia, against the petitioner. Full stop. The matter is at such preliminary stage. Full stop. Following the May 18, 2023 order of the Lokayukta, passed by only its chairperson and not as a part of any bench, the special court in Tura has taken cognizance of the matter by an order dated May 23, 2023, required summons to be issued against all the persons named in the order dated May 18, 2023, including the petitioner herein. Full stop. At the time that this petition was received in this court, the petitioner questioned the validity of the amending acts and claimed that the principles of natural justice had been completely violated. Full stop. On June 12, 2023, this court received the petition and provided in its order of such date as follows. Next line, the second last paragraph. The investigation will continue in terms of the order impugned, without prejudice to the rights and contentions of the petitioner herein, full stop. However, if the need arises to arrest the petitioner, such arrest may not be made without leave of this court, full stop. Paragraph. According to the petitioner, the entire scheme of the original act has been turned on its head, and though the state legislature initially intended a serious matter as a complaint against a public servant discharging his official duty to be considered by a body which was to be called the Lokayukta, the amendment has stripped the body down to a solitary person. Full stop. This, according to the petitioner, is completely arbitrary and apparently not in consonance with Article 14 of the Constitution. Full stop. Several provisions of the original statute have been placed, including the constitution of the body known as the Lokayukta, the selection of the procedure for appointment of the chairperson and members of such body, and the selection committee which would recommend the names for the appointments to be made therefrom. Full stop. On the paragraph merits, section 20 of the Act has been copiously placed to submit that before proceeding against any person other than an accused, notice has to be issued to such person and such person's views obtained. Good stop. Paragraph.
Lordship, that was, I'm very sorry to interrupt, Lordship. That is section 21, which has that provision. Section 20 is the one on. I'm very sorry to
section
interrupt,
21.
Lordship. Section
21.
At 70. Yes, at 75.
Section 21.
That's the one.
Yes.
And 20 is the one where three members try to.
Section 20 of the original Act has also been placed to emphasize that upon receipt of a complaint, it was the body of the Lokayukta which had to call for a preliminary inquiry, and by the subsequent amendments, and by the amendments, particularly the amendment contained in section 2 of the Amending Act of 2019, section 5 of the Act may have been altered, but section 20 of the statute remained unaffected. Full stop. Paragraph. Particular objection has been taken to section 2 of the Amending Act of 2021, both in its first and the fifth subsections. Full stop. In effect, the amendment provides for the Lokayukta to be run singly by its chairperson without the assistance of any member. Full stop. Paragraph. There is no dispute that it was the state legislature which enacted the original statute in 2014, and such legislature had due authority to alter or amend the provisions thereof. Full stop. The impugned amendments, full stop, just as the assembly, the state assembly, deemed it fit originally for the Lokayukta to be a body of several persons, comma, it could have, comma, provided for a Lokayukta to be a single person authority, full stop. There was neither any impediment at the initial stage nor at any subsequent stage on the State Assembly to decide on the constitution and composition of the Lokayukta, and merely because it had once indicated that the Lokayukta would be a body of persons would not stand in the way of the State Assembly altering its original position to provide for a one-member Lokayukta. Full stop. Paragraph. Further, comma, since the legislature, state legislature had due authority to amend its own acts in such manner as it thought fit, comma, the introduction of the proviso to section 5 by the 2019 amendment would be all pervasive and cannot be said to be confined to section 5 alone. Full stop. Paragraph. Section 5 of the Act in its original form requires appointments to vacancies, vacant posts to be made. Full stop. By adding the proviso, comma, the legislature clarified that if the body that was contemplated to be the Lokayukta was not complete upon vacancies not being filled up, comma, that would not stand in the way of the available persons in the organization continuing with the activities as empowered. Full stop. As a consequence, comma, the proviso would have an effect on all the other provisions of the original statute, comma, including section 20, which provides for members sitting along with the chairperson to require a preliminary investigation or inquiry to be made. Full stop. Paragraph. There does not appear to be any arbitrariness in the state assembly, state legislature having amended the act that was the same legislature's doing. Full stop. No prejudice on the ground of Article 14 has been demonstrated except by referring to such constitutional provision. Full stop. Paragraph. a certain complaint was made in respect of certain matters involving the use of public funds. Full stop. A preliminary inquiry was called for by the Lokayukta, which resulted in several other names coming up apart from the person or persons originally complained against. Full stop. Upon receiving the preliminary report, due notice was issued, in compliance with the principles of natural justice, to the petitioner herein, whereupon, the petitioner claims to have made an oral representation before the Lokayukta by attending its office after receiving the notice of May 18, 2023.
Lordship,
March 14, 2023. Full stop.
That notice was not from the Lokayukta, Lordship. That was from the investigating officer. The 14/3/2023 notice at
14/3/2023 by
investigating officer.
By presenting himself before the body charged with making the preliminary investigation. Full stop. I said Lokayukta before, just cut that out. Full stop. Paragraph. At the highest, the best arguable case of the petitioner is that the order dated May 18, 2023 passed by the Lokayukta may have been without notice to the petitioner and without affording the petitioner an opportunity of being heard. Full stop. However, such notice causes no prejudice to the petitioner since the matter has been referred to the special court for the special court to file charge sheets under certain provisions. Full stop. There is no doubt that the petitioner will be heard as summons have already been issued. Full stop. At any rate, if there is any grievance in such regard or any infraction that the petitioner can rightfully complain of, this is not the forum for the purpose, full stop, paragraph. It appears that a sham challenge to the amending acts was made out for the purpose of stalling the proceedings initiated by the impugned order dated May 18, 2023, full stop. Since there is no basis to the challenge to the amendments, WP number so-and-so is dismissed with full prejudice to the petitioner for its consequences, there will, however, be no order as to cause.
Would Lordship grant me another moment's indulgence?
Yes.
Just for one other clarification,
yes.
Lordship. I'm seeking your Lordship's indulgence. I feel that I have not been able to make that case good. When
yes.
I said manifest arbitrariness, I was not questioning the authority of the Legislative Assembly to make the amendment. My point was somewhat different, Lordship. I was saying that the Amendment Act only amends one particular section, Section 3, and in saying that the Lokayukta will now comprise of the chairman.
We've said, we've answered that, madam, that it's all pervasive. By reason of that amendment, every other provision gets affected by it.
I understand, Lordship. I submit to that. But just the one point that other sections which refer to a body of the Lokayukta have not been amended. So if one were to read the Act together, sometimes the reference is to a body and sometimes in just one section, it refers to a single person. That is the only clarification I sought to make.
Thank you.
I'm obliged, Lordship.
First question.
Item 3.
The petitioner? I have no idea. Yes.
May I please?
Where are we, sir? What does that mean? Washed away by the rains?
I'm sorry, Lord.
Where? How far is the MPT road complete?
So far, as per the last order, the petitioner had a query about from 57 to 100 stretch. Let's see that there we have accomplished 15% of the total work, and the total working period allotted to the company is 24 months.
How about the bridges?
Bridges,
The bridges are in good repair.
No, 4 number of bridges Lordship, due to overplying of vehicles, heavy vehicles and construction materials Lordship. These 4 RCC bridges Lordship.
And that road will have to be widened, will have to become, because once the bridge from Dhubri to Fulbari is complete, that will be the major road.
Lordship, yes.
So to gear up to that,
Lordship, yes. We are taking all the
Fulbari will become a major trading place.
Lordship.
And naturally a lot of criminal activity.
Lordship, yes.
Wherever there is money, the goons go before.
Lordship. So Lordship, so far the query of my friend,
Yes, sir.
petitioner is concerned.
May I please, Your Lordship? This road from 32 to 41 is completely damaged, my lord. On 2nd July, I have checked, completely damaged. And moreover, 67 to 100 kilometer, my lord, there is water logging during these rainy seasons. So the department can do, because vehicle cannot move. So some drainage system for
The
temporary.
petitioner complains that despite the previous order requiring immediate repair work to be undertaken for the 9-kilometer stretch between kilometer 33 and kilometer 41, nothing serious may have been done, and potholes have developed which seriously affect the movement of traffic along this stretch. Paragraph. As far as the 67 to 100 kilometer stretch of the MPT road is concerned, even though the previous order noticed that the levelling had been completed, the petitioner says that there is massive waterlogging along large stretches which have completely eroded the blacktop and make it difficult for trucks and almost impossible for smaller vehicles to navigate such stretches. Full stop. Paragraph. The AMPT road is an arterial road of great importance already, and with the bridge across the Brahmaputra from Dhubri
to
Fulbari scheduled to be completed in the next 3 or 4 years, Fulbari will develop as a major trading hub, and roads to and from Fulbari will have to endure much greater traffic than can be imagined at present. Full stop. Paragraph. For such purpose, the AMPT road has to be in top condition without excuses such as rain being cited to explain away its pitiable condition, full stop. This matter has lingered for a considerable period, and though some progress was made on some stretches, it does not appear that the work undertaken has any lasting value, full stop. The state PWD roads would do well to look into the matter, and instead of spending over and over again for patchwork or repair work, undertake an altogether overhauling of the road, whether or not in conjunction with the National Highways Authority of India, so that the road can cater to the increased demand, increased pressure upon the Dhubri to Fulbari bridge over the Brahmaputra being completed. Full stop. Paragraph. The state PWD roads should consult with NHAI or its arm, the National Highways Infrastructure Development Corporation Limited, and possibly seek funds from the Northeastern Council for the strengthening, widening and year-round maintenance of the AMPT road as a part of the extension of the Dhubri to Fulbari flyover. Full stop. Paragraph. This does not imply that the outstanding work or the patchwork that is immediately required should be ignored. Full stop. It is a matter of concern that despite it being well known that Meghalaya is one of the wettest places in the world, the same excuse of rains is given by the state or other authorities to justify the poor conditions of some of the roads. Full stop. Indeed, there are several other roads in the state which can endure the monsoon and remain unaffected by the heavy rains. Full stop. Paragraph. Since the AMPT road is one of the key roads on the linking the western part of the state to the rest of the state and even other parts of the country, it requires special attention, and it is hoped that the state PWD roads will deal with the matter with the requisite seriousness. Full stop. Paragraph. A report as to the measures taken, including how the road should be some 4 or 5 years from today, should be filed by the state when the matter appears next, 6 weeks hence. Full stop. In the meantime, comma, the potholes and potholes along the stretches should be filled up temporarily so as to make the road more accessible to lesser vehicles. Give it a date after 6 weeks.
My lord, so far 32 to 41 is concerned, Lordship. 3 numbers of contractors were allotted with the work and they have already given their undertaking. During this period, all the portals filling up and
Very
repair will be done.
Six contractor, my
The
lord,
state
not
says
one.
that for the 33 kilometer to 41 kilometer stretch, 3 contractors have been engaged and they have undertaken to continue continuous repair work to ensure that that such stretch is navigable during the monsoon months.
Sir Lordship, this regarding this NEC, Lordship, NEC is not giving any fund for repairing.
That is why we have included over here. That is why we've included over here. The NEC is sitting over a lot of money it wants to give. But if you do not give viable projects, you have to make viable projects. NEC will not give money to anybody and everybody. NEC will look at viable projects. So you make it out to be like we've made it out to be. You have to connect. That bridge is happening, for which heavy vehicles are already going, taking the MPT road for the purpose of construction of the bridge. Have you seen how much of the bridge is completed? So heavy vehicles are already taking that road. Once that bridge is completed, everyone going to the Barak Valley or to that part of the northeast will no longer have to go to Upper Assam. Any traffic coming from, the North India, elsewhere in India, will not have to go through that part. From Dhubri straight it will come to Fulbari and cut across Meghalaya. Only Guwahati and North Assam bound traffic will not take it. It's an alternative route. So if you make that kind of a pitch to the NEC, you'll get funds.
That's right.
You have to sell yourself to be able to get the funds.
So far as the Lordship bridges, RCC bridges, Lordship, 4 number of bridges, Lordship, there is immediate repair. And in order to maintain the flow of the transport vehicle, we are even constructing the surveys, and it will be completed within 2 months, Lordship.
Very well, we are not specifically referring to it, but yes.
Item number 4.
Yes, sir.
May I please, my lord? It's the same matter which was heard little.
Sorry?
It is the same matter, my lord, if you
Yes,
remember,
yes.
you heard in a bit, my lord. My lord, the gist of the matter is that an FIR was filed on 23rd October 2015 by father, my lord.
23rd October.
October 2015 about the missing of his son, my lord. On 21/10/2015 from their residence, my lord. At Pilankata,
Missing son, missing from
the residence.
2110.
10, my lord.
Yes. Where was it filed?
It was filed before the officer in charge Pilankata police outpost under Khanapada police station, my lord.
Pilankata police outpost
Under Khanapada police
Khanapada.
station, my lord.
Yes.
My lord, thereafter, it is said that on 22nd 10/2015, the complainant received a ransom call, my lord, at his mobile number.
That the FIR said it. Let's read the FIR.
FIR is at page 2, my lord, the typed copy. My lord. Sir, with reference to the subject cited above, I would like to file an FIR on this date, the 23rd October 2015, that on 21st October 2015 at about 10 a.m. my son went out from home along with Mr. Ajay Sangma of Chibra village and he has not returned home since then. On 22nd October 2015 at 11 a.m. I received a phone call bearing number so-and-so demanding a sum of 10 lakh only for the release of my son. I also noted that they communicated to me in Garo and Assamese language. I was warned not to approach the police for help. Therefore, I would urge you to make all efforts and necessary actions thereof to rescue my son at the earliest. This is the FIR, my lord. My lord, thereafter...
You are Ajay Sangma.
I am Ajay Sangma, my lord. I am Ajay Sangma. My lord, thereafter... the charge sheet was filed, my lord. And I was arrested on 30/10/2015, my lord.
Yes.
Yes.
And since then you're there.
I'm in custody, my lord. I'm serving now. My lord, charge sheet was filed on 29/2016 under section 364 within bracket A, 34 and 302 IPC against 3 accused, my lord.
Ajay Sangma.
Ajay Sangma, my lord.
And who are the other two?
Other 2 is absconding, my lord. The third one is absconding, and the second one is before your lordship in the second appeal, my lord.
Second one is?
Akwit Marak, my lord. Akwit Marak. He is in the next appeal, my lord.
His name is Akwit Marak.
Akwit Marak, my lord.
Has he been acquitted? No.
Not yet, my lord. We are before you, my lord.
How do they spell acquit?
ACQUIT, my
Oh,
lord.
same.
Same, my lord.
Akwit Marak.
And Sengsang, my lord.
Absconding.
No, he is before there, my lord. He's
The
before
third
you.
one is absconding.
The third one is absconding. Sengsang, my lord.
Very good.
My lord, charge sheet was filed. Charges were framed. My lord, may kindly come to the charge sheet, my lord. The charge sheet, the operative part of charge sheet is, my lord, at page 21, my lord, of the paper book.
Yes.
My lord, if I may be allowed to read the charge sheet, my lord. My lord, the prosecution story of the case is that on 23rd 10/2015 at about 5 p.m. one Rahim D. Sangma, he is the father of the complainant, my lord, of so and so, submitted a written FIR to the effect that on 21/10/2015 at 10 a.m. his son master Prem D. Sangma, 16 years, went out from home along with Ajay Sangma of Chibra village, PS Khanapada, PO Pilankata, so and so, my lord. Thereafter, my lord, however, on 22/10/2015, he received a call on his mobile number at so and so from unknown mobile number so and so, my lord, and demanding the sum of rupees 10 lakh as the ransom for the release of his son. And the person were communicating in Garo and Assamese languages and also warned not to approach the police for help. The case was started and I, SI K. Thapa, took up the investigation of the case. During the course of investigation, visited the PO is that Umtringa village under Pilankata PO Pilankata, PS Khanapada, District Riboy, Meghalaya, which is approximately 3 kilometers from this OP towards south, held confidential inquiry and learned that on 21/10/2015 at 10 a.m. Master Prem D. Sangma, 16-year son of so-and-so was at home. Meanwhile, Shri Ajay Sangma of Chibra village, PS Khanapada, Pilankata, Rebhoy district was standing outside the house of Master Prem D. Sangma and asked his sister, Miss Rani D. Sangma, 11 years, to call his brother Prem outside as he wanted to talk to him, who was at that time was inside the house. Accordingly, she went and called him, and her mother, Srimati Dorchon D. Sangma, out of curiosity, went at him and saw Ajay and Sangma standing near the gate. My lord, if I may allow to state here, this does not concur with the evidence given by the mother, that is PW2, my lord. She has not said that she went out and saw me standing outside the house. I will come to it later, my lord. Then Master Prem D. Sangma went and met him. For a while they had a conversation and left, and has been seen both of them were travelling in a commercial vehicle, white magic number not known, proceeding towards Basishta Charyali, Guwahati, Assam, and since then he as well as Ajay Sangma has not returned back. Thereafter, my lord, on further inquiry, it appears that the victim was kidnapped for ransom by applying inducement by deceitful means by Shri Ajay Sangma and other unknown persons. A secret inquiry was held, however, nobody could provide the information of the victim as well as the Ajay Sangma apparently kidnapper. It is to be noted that the victim father Sri so-and-so had already received a call at his mobile number so-and-so from unknown number so-and-so and demanding a sum of rupees 10 lakh as the ransom for the release of his son. On 22/10/2015 at 11:10 a.m. and source has been engaged, accordingly call detail record so-and-so was obtained from service provider the interest of the case. On analysis, conversation has started so-and-so, lord, and thereafter, my lord, also received the customer application form on the mobile number so-and-so, which was in the name of Srimati Payal Mahato of Nagaland, my lord. WT message was sent and flashed to the OC Dipu Par, Dimapur, Nagaland, but no reply. It appears that the said SIM card which has been used by the kidnappers is black SIM card which have the identity of the other purpose. Therefore, it is difficult to trace out. So, my lord, the caller, the SIM in whose number it was registered, my lord, was never found, my lord. It could never be detected. Examine number of witnesses and engaged source. During the further course of investigation, accused so-and-so was arrested and taken into police custody. He was thoroughly interrogated in custody and he told that he and victim Prem D. Sangma has been kidnapped by unknown persons from Basishta Mandir and he was shot twice by the unknown persons in where he pretended to be dead. He also showed his bullion and this story was not corroborated, my lord. The sweater where he alleged that he has been shot was sent to forensic. There was no gun residue found, my lord. And thereafter, my lord.
This is your story?
This is my story, my lord. He was seen going out together with victim Prem D. Sangma on 21/10/2015 by the witnesses Srimati Dorchon D. Sangma and Dear Sangma. Now, here, my lord, again, the thing is that it has been named that PW2, the mother has seen him last, which is again not corroborated nor concurred, my lord, in her deposition. He also revealed that the whole plan was constructed by the person with Anthony G. Moment for kidnapping the victim Prem D. Sangma and was offered an amount of 10,000 rupees. Efforts were made to arrest Anthony G. Sangma, but in vain. The accused Ajay N. Sangma expressed his willingness to lead the police party to arrest the other co-accused. On his leading his period in police custody, one of the accused, Akwit Armarak, the second appellant, my lord, was arrested from the village Borjhar, Garopada, PS Dudnoi, so-and-so. He was arrested and taken into police custody. During their period in police custody, they were interrogated thoroughly. During the course of investigation, both of their statements contradict with each other and pressure was given to them to tell the truth, and finally they revealed that the victim Prem D. Sangma is killed and was thrown at the reserve forest. However, they denied in telling the truth who killed the victim Prem D. Sangma, but they expressed their willingness to lead the police party to recover the dead body of Prem D. Sangma. On their leading, in presence of independent witnesses, Shri so-and-so of Assam, my lord, they are the headman and secretary of the villages, my lord. The dead body of the victim, Prem D. Sangma, was recovered from the reserve forest of Borjhar, Garopara in highly decomposed state. Accordingly, held inquest and searched the PO surrounding but could not find anything to seize. Thereafter, my lord, the charge sheet has been filed against 5 of them, my lord. 5 of them, 6 of them, my lord, but they are yet to be arrested. Now, I may take, my lord, to PW1, my lord, at page 32. PW1 is the complainant, the father, my lord.
The evidence.
The evidence, my lord. At page 32 of the paper book. My lord, it says, I received summon to depose before the court. I know the case as I am the complainant of the instant case and the deceased victim.
This is it.
My lord.
Yes.
I received summon to depose before the court. I know of the case as I am the complainant in the instant case and the deceased victim Prem D. Sangma is my son. On 21/10/2015 at about 8 a.m., my deceased son went out of the house and was missing since then. Now this is important, my lord. I was informed by the brother of the accused, Ajay Sangma, that my deceased son went with accused Ajay Sangma in a passenger vehicle. Thereafter, I received a phone call from the kidnapper and demanded so and so as ransom money for release of my son. On 22/10/2015 at about 10 a.m., the kidnappers conversed with me in Garo and Assamese language. They asked me to pay the ransom money or they will kill my son, and also threatened me and asked me not to inform the matter to the police. Thereafter, we tried to trace our son but fails to locate him. So on 23/10/2015, we lodged FIR before the in charge Pilankata police outpost. So an exhibit so and so is my signature. Now, next paragraph. My deceased son was recovered from a jungle at village Borjar on the lead of accused Acquit R. Marak. My lord, this again contradicts with the statement of the police, which says that I led, not the second appellant, my lord, to recovery of the body, my lord. Now, in the cross-examination, my lord, it is a fact that I lodged the FIR after 2 days of the incident. On the day of missing, my son was wearing army print full sleeve t-shirt and a half pant. It is a fact that at the time of lodging the FIR, I did not mention any name, as I did not know who committed the offence. It is a fact that I accompanied the police only on the day of recovery of my deceased son. It is a fact that initially I did not know from where the accused person were arrested, but later the police told me that the accused persons were arrested from the same village, is that Borjhar, Garopara. My deceased son was wearing the same clothes at the time of recovery. Now, I may take your lordship to PW2, this deposition of the mother, my lord, at page 34 of the paper book. My lord, she said, I received summon to depose before this court. I know of the case as the deceased victim Prem D. Sangma is my son. On 21/10/2014 at about 8 a.m. went out of the house and disappeared. And since then, later at around 10 to 11 a.m., one person, namely Dear D. Sangma, informed me that he saw my deceased son left with Ajay Sangma in a vehicle. Now, my lord, charge sheet says that PW2 came out of curiosity when the sister of the victim came inside to call the victim that I am standing outside and wish to speak to her brother, the victim, my lord. Thereafter, my lord, it's the deposition of number 3, who apparently saw the victim living with the appellant, my lord. My lord, it is at page 35 of the paper book, my lord. And he says, my lord, I received the summon issued to me by the honorable court. I know Ajay and Sangma as
Who is this person?
he is the cousin, my lord, of the appellant, and my lord, apparently he is the one who said that I have seen the victim going on with the appellant, my lord. But again, there are certain points which needs to be taken into consideration, my lord. I know Ajay and Sangma as he is related to me. My mother is the elder sister of Ajay and Sangma mother. I do not know Shri Premdi Sangma. I saw the accused Ajay Sangma along with a small boy. My lord, the victim here is said to be 16 years of age, my lord. And here he is speaking about a small boy, my lord. My lord, on the last time, if your lordship remember, said that small boy maybe it's a matter of interpretation, my lord. But here, my lord,
an old man like me can call you a small boy also.
Exactly, my lord. Exactly, my lord. But here he is just about 25 years of age, my lord. So for him, a small boy may not be a 16-year-old boy, my lord. At around 8 to 9 a.m., inside the magic vehicle proceeding towards Charayali, Assam side, I know the father of the small boy again, who was with the accused person Ajay and Sangma. The father of the small boy is Rahim Sangma and he is a resident of so-and-so. The father of the victim asked me if he had seen the victim. I said yes. I saw the victim sitting in the vehicle along with the accused person. Now, my lord, PW1, the father never said that he asked the PW3, my lord, whether he has seen my son. And he is saying here, my lord, that he was asked by the father. Now, my lord, at page 37 is the deposition of the doctor, my lord, who had conducted the post-mortem of the body, my lord. His opinion is that, my lord, that as per my finding, I am of the opinion that the wound which was caused in the neck of the deceased might have been due to the sharp object such as knife or a dao. Now, second part of it, my lord, one of the accused person had stated that he had heard a firing shot, my lord, which apparently was meant for the victim, my lord. In the charge sheet as well, when the third accused was interrogated, my lord, after he was arrested, his version was that I had heard a gunshot. And the post-mortem report says, my lord, that the victim had died with a cut which was made by a sharp object like a knife or a dao, my lord. My lord, then I take your lordship to page 48, the deposition of the investigating officer of the case, my lord. My lord, I will not read the entire part because this is just the narration which are facts, my lord. Paragraph 1, 2, 3, 4, 5, my lord, is important at page 49, my lord. My lord, it reads as, on receiving the said complaint from Rahim D. Sangma, I made a discreet inquiry and learned that on 21/10/2015 at about 10 p.m., accused Ajay and Sangma has come to the house of the victim Prem D. Sangma and was standing on the premises of Rahim D. Sangma house. Then Ajay and Sangma saw Prem D. Sangma's sister Rani Sangma. Rahim Sangma was outside the house. Accused Ajay and Sangma asked Rani Sangma to call the victim Prem D. Sangma. After a while, Prem D. Sangma came out of the house and met Ajay and Sangma. They were last seen travelling in one magic van towards Basista side. Further, it is learned that accused Ajay and Sangma has deceitfully kidnapped victim Prem D. Sangma to unknown destination. The source was engaged to trace out the accused Ajay and Sangma and the victim Prem D. Sangma. I have submitted call detail of the mobile number which has called the victim's father for a ransom. On 29/10/2015 at morning time 10 a.m. to 10:30 a.m. received source information that Ajay Sangma is at Krishnai PS. Accordingly, I along with staff proceeded to Krishnai PS to apprehend the said accused. On arrival at Krishnai PS, I met second OC Sri so and so, and on inquiry from him I came to learn that on 27/10/2015 they received a call from on one Line Hotel located at Salpara that accused Ajay and Sangma was rescued from the jungle and he is taken to Line Hotel. Thereafter, my lord, at paragraph 9.
Just 1 minute. Yes.
My lord. My lord, here at paragraph 9, my lord, the investigating officer says that Anthony Momin of Chibra village constructed the whole plan, my lord. Now, what is important, my lord, in the entire is paragraph 10, my lord, at page 52, wherein the investigating officer says that he had seized one prepaid Aircel SIM card and one memory card and one bullet jacket from me, my lord. At page 53, my lord, at paragraph 2, which was continued the chief, my lord, he has stated on leading of the arrested accused, Ajay and Sangma, I along with forces went to Krishnai police station and met second officer so-and-so. I seek assistance from him and he provided ASI so-and-so to assist me. Then I along with forces went to Borjhar, Garopada village on the leading of the accused Ajay and Sangma. While walking towards the village, accused Ajay and Sangma identified one person which was coming from opposite direction in a bicycle and told that he is also a part of the group. Accordingly, he was detained and interrogated and he reveals that his name is Akwit Armarak and resides at Borjhar Garopara and he used to cook food for them and he dropped the food to the reserve forest where the other co-accused and the victim were stationed. Then he agreed to lead the arrest of one of the co-accused, namely Sengsang K. Sangma, who is absconding, my lord, of Borjhar Garopara. A raid was conducted at the house and it was found under locked and key. And on inquiry, it is learned that Sengsang K. Sangma was last seen on the village on 27/10/2015. Further, on leading of the arrested accused Ajay Sangma and the accused Akwit Armarak, a search was also conducted to recover trace out the victim Prem D. Sangma but could not be found. Now, he has led, my lord, but nothing could be found. But then in the same breath, later on it has been stated that these two had led to the recovery of the body, my lord. On the next day, he was arrested and forwarded to the court with a prayer for police custody, and during his police custody, he was interrogated thoroughly and he stated that on 21/10/2015, Sengsang K. Sangma of Borjhar Garopada village came to his house and gave him rice, dal, pulse and vegetables to cook food for him and his friends who is stationed in Reserve Forest Mzonga, and Sengsang K. Sangma threatened him to shoot if he did not cook the food. He used to prepare the food and dropped the food at the jungle where he saw the victim Prem D. Sangma and was tied with a rope and kept as a hostage. Sometimes Sengsang K. Sangma came and collected the food from his house after the day of 6th or 7th. He was not told not to cook food for them as they are releasing the hostage. However, he stated that since Ajay and Sangma and Anthony G. Momin are from the same village, so both of them were insisting one of the co-accused, Greting Marak and Gautam Basumatari, not to release the victim Prem D. Sangma. Then accused Akwit Armarak and Ajay and Sangma were put to sit together for further interrogation, and during interrogation, both of their statements contradict with each other. Later, accused Ajay and Sangma and accused Akwit Armarak voluntarily confessed that the victim Prem D. Sangma was killed and thrown in the reserve forest Mzonga. Both the accused Ajay and Sangma and Akwit so-and-so were willing to lead the police party to recover the dead body of the victim. The matter has been reported to so-and-so. Now may I take your lordship to paragraph 9. On leading of accused Ajay and Sangma, Akwit Armarak went to village Borjhar Garopara and there we called independent witnesses. One headman, so-and-so, my lord, who are presently at police to recover the dead body. At paragraph 10, my lord, he says, the arrested accused Ajay and Sangma and Akwit R. Marak lead the police as well as the independent witnesses to the place where the dead body was kept. On arrival at the place of occurrence, it is a reserve forest situated in the outskirts of the village Borjar Garopara, and the jungle is very thick and dense. After a brief search, the dead body was recovered in prostrate position and the hands was tied from behind his body and head skull was detached from the body. The body was highly decomposed in a worm-eating condition. Accordingly, held inquest over the dead body on identifying by the victim's father, Rahim D. Sangma, in presence of independent witnesses. In the inquest report, I have commented that the corpse of the victim appears to have been killed 7 to 8 days back. Therefore, it is highly decomposed. To ascertain the actual cause of death, to the dead body sent to civil hospital through so and so, and a postmortem was conducted. My lord, what I say is that, my lord, at the first part, the investigating officer says that both of them were led and nothing could be found. Later on, he says, my lord, that these two had led me to recover the body, my lord. Then, my lord, may kindly come to page 60, my lord. 4-5 lines from top, my lord. It is said, but the arrested accused, Sengsang Ke Sangma, do not know who killed Prem D. Sangma. He just heard the sound of the firing, as their arms were held by grating R. Marak, and he was little bit far away at that point of time. My lord, now I may be allowed, my lord, the certain points which I have made out, my lord, in the entire investigation and in the entire deposition. My lord, the first is that it is admitted and it is on record, my lord, that a mobile phone was seized from me, a mobile SIM card was seized. My lord, there was no location traced out by the investigating officer to pinpoint that I was around the place where the dead body was found, my lord. My lord, there is only apparent one eyewitness, my lord, the sister of the victim, who had seen me that I was going out with the victim, but she was never examined, my lord. She was never examined by the Rani D. Sangma, my lord. She was never examined. My lord, as far as the issue of the investigating officer, again, my lord, when I was arrested and it was said that in the FIR that he was last seen with me, no endeavor was made, my lord, to search for the victim at that point of time, my lord. My lord, another important part of is that when the dead body was recovered, my lord, it was identified by the father, my lord. My lord, no superimposition test was done, my lord. No DNA test was done, my lord. Now, I have some rulings which I'll take, your lordship, my lord, from Apex Court, that it cannot be relied if the body is decomposed, my lord. My lord, it was only identified.
Clothes were there.
My lord? Clothes, only clothes, my lord. Only
clothes were there.
Clothes were there. But the body.
He is asserted he was wearing the same clothes.
That is all, my lord. That is all, my lord. My lord, another part was that I was seen last with the victim, my lord, about 10 days. So the last in theory does not corroborate, my lord, that I was the last person with whom I have seen, the victim was seen with me, my lord. The entire case, my lord, stands on circumstantial evidence, my lord. Because Dear and Sangma, he says that I had seen a small boy. PW1 says that I was informed by Dear Sangma whether he has seen my son. Dear Sangma says that I was informed by... These all loopholes are there, my lord, because the statements cannot be taken at the face value, my lord. My lord, I may be allowed to take your lordship to...
Already over facts and into law. Which means no defense on facts.
No, defense on facts, yes.
Law we will distinguish everyone that you show.
My lord,
How is it that you led them to the
my lord,
place
father,
where the body was buried?
my lord, father says something else.
Father may say something else.
My lord, section 27 was not complied, my lord, because when I said I am leading the body, my lord, I am leading for the recovery of the body, my statement was never recorded by two independent witnesses by the investigating officer of the case, my lord. My lords, I narrated this fact, or I narrated before.
There is no document, Mr. Bhattacharya.
Pardon, my lord.
There is no document reducing that he is leading them to the body.
My lord, 27 has not been applied with, but then this will come under section 8 of the Evidence Act, as well, my lord, supported by judgment by your lordship, my lord. Because there is a requirement in law, my lord, when recovery is made at the instance of the accused, my lord, then in such a case, the accused is bound to give some explanation. In a failure to do so, my lord, there may be
But the very recovery by at the behest of the accused is in doubt.
No, my lord, there is no doubt about that, my lord, here. That has not been doubted, my lord, and I don't think, my lord, they have denied. Kindly see the cross-examination of the IO, my lord. They have never disputed it, my lord.
Anyway, you carry on.
My lord, my lord.
Let us come to the IO once again.
My lord, IO has to be, my lord, read as a stretch, my lord. My friend is leaving some part, reading.
Yes, IO, because there are certain parts that we find of the IO. Come to page 53.
My lord. I may read it, my lord.
Yes.
Chief examination continues, my lord. I have received.
53 says that I, along with forces, went to Borjar on the leading of accused Ajay. While walking towards a village, accused Ajay identified one person which was coming from on a bicycle and told he is part of the group. Accordingly, he was detained and interrogated, and he reveals that his name is Akwit, resides at Borjar, and he used to cook food for them and drop the food to the reserve forest where the other co-accused and victim was stationed.
My lord.
So he points out to another person, that person makes this statement.
My lord.
Effect of that we'll see later.
My lord.
Then he agreed to lead the arrest of one Seng Sang.
My lord.
Found under lock and key, it is learned Seng Sang was last seen on 27/10. So Seng Sang is absconding.
Absconding, my lord.
On leading of the arrested accused Ajay, a search was conducted to recover victim but could not be found. On next day, he was arrested, forwarded to the court with a prayer for police custody, and during his police custody, he was interrogated thoroughly, and he stated that on 21st, Seng Sang came to his house and gave rice, dal and pulse vegetables. This is Akwit.
Acquit, my lord.
This is referring to Akwit.
Acquit, my lord.
He used to prepare the food, drop the food, and saw victim. Please read the bottom of 54. From sometime Seng Sang came and collected the food.
My lord. Sometimes Sangsang ke Sangma came and collected the food from his house. After the day of 6th or 7th, he was not told not to cook food for the for them as they are releasing the hostage. However, he stated that since Ajay and Sangma and Anthony Joe Momin are from the same village, so both of them were insisting one of the accused, Greting Marak and Gautam Basumatari, not to release the victim Prem D. Sangma. The accused Akwitar Marak and Ajay Sangma were put to sit together for further interrogation, and during interrogation both of their statements contradict with each other. Later, accused Ajay and Sangma and accused Akwitar Marak voluntarily confessed that the victim Prem D. Sangma was killed and thrown in the reserve forest Mzonga. Both accused Ajay and Sangma and accused Akwitar Marak were willing to lead the police party to recover the dead body of the victim. The matter has been reported to the senior officer and I was allowed to go to Borjhar, Garopada, Mzonga for recovering the dead body. On 3/11/2015, I, along with police forces on the leading of the arrested accused Ajay and Sangma and accused Akwitar Marak, went to Borjhar, Garopada village. Before going to the village, went to Dudnoi police station and reported the matter to the officer in charge, and he deputed one UB constable to assist us. On leading of accused Ajay and Sangma and Akwitar Marak, who went to village Borjhar, Garopada, and there we called independent witnesses. One headman, one secretary and one member, and explained them that we are the police were led by the arrested accused Ajay and Sangma and accused Akwitar Marak, who are presently at police custody, to recover the dead body of the victim, Prem D. Sangma, and requested them to accompany the police during the search and recovery of the dead body. The arrested accused Ajay and Sangma and Akwitar Marak led the police as well as the independent witnesses to the police place where the dead body was kept. On arrival at the place of occurrence, it is reserve forest situated in the outskirts of the village Borjhar, Garopada, and the jungle is very thick and dense. After a brief search, the dead body was recovered in prostrate position and the hand was tied from behind his body. His head / skull was detached from the body. The body was highly decomposed and in worm-eating condition. Accordingly, held inquest over the dead body on identifying by the victim's father Rahim D. Sangma in presence of independent witnesses. In the inquest report, I have commented that the corpse of the victim Prem D. Sangma appears has been killed 7 to 8 days back. Therefore, it is highly decomposed to ascertain the actual cause of death. The dead body is sent to Civil Hospital Nongpo for PM examination. I have appended my signature so and so. After observing the formalities, the dead body was brought at Nongpo Civil Hospital for conducting post-mortem to ascertain the actual cause of death. So and so is the challan. The photograph of the dead body was also taken at the place of occurrence. Exhibit 7 is the said photographs and I have certified to be true copy by appending my signature so and so the place of occurrence. I have certified to be true copy by appending my signature. Later on, 18/12/2015, received post-mortem report of the deceased and Dr. D.M. Momin so and so opined the cause of death was shock due to hemorrhage caused due to incised wound on the neck by sharp object. Then on 5/1/2016, I received a source information that one of the co-accused Sengsang K. Sangma, who is wanted in connection in this case, was arrested by Assam police. And the case was registered at Dudnoi police station and is presently lodged in Gwalpada district jail. Accordingly, a prayer to issue production warrant was submitted to the learned CGM. I received the copy of order passed by Srimati So-and-so Nongpo Court, Ribhoi district, issuing a production warrant against the wanted accused Sengsang K. Sangma and was required to produce on or before 11/1/2016. On 6/1/2016, received forensic science laboratory report black with woolen jacket with blood, which was seized from the possession of the arrested accused Ajay and Sangma, who claimed that the initial stage that the jacket was torn due to gunshot in which he survived in order to corroborate his statement. I had seized the said jacket and the same I sent for FSL examination to prove the claim of the arrested accused person, and the scientific officer physical division so and so opined that the gun residue could not be detected on the clothes which was seized by me. On 7/1/2016, I went to Gwalpada District Court for execution production warrant against the accused Sengsang K. Sangma. After observing all the formalities, Sengsang K. Sangma was brought from District Jail Gwalpara to Pilankata Police Outpost. On 8/1/2016, the arrested accused Sengsang K. Sangma was forwarded to the Honorable Court with all connected papers and prayer for 4 days police custody, and the same was allowed. During police custody, the co-accused Sengsang K. Sangma was interrogated thoroughly. The accused Sengsang K. Sangma stated that he resides at Borjar Garopada under Dudnoi so-and-so. He has joined National Democratic Front of Bodoland on 2010, but he quitted National Democratic Front of Bodoland and joined another organization called Achik Liberation Army. Further, he stated that on the month of October 2015, but could not remember the date, one of the former cadre of NDFB named Gautam Basumatari and Greting Armara contacted him over phone and told him to meet them at Kachua Bazaar under Gwalpara district as they have some urgent work to discuss. 1 week before festival of Durga Puja start, he met Gautam Basumatari and Greting Armarak at Kachua village under Gwalpara district 1 week on weekly market which is held on Sunday. When he was told by Greting Armarak that some of his friends will be kidnapping a person from Meghalaya side, so he was told that they need him to guard a person as they know him. He is from the organization United Achik UALA, as he is also offered 50,000 for bringing their arms and 50% of the ransom money. After 3 or 4 days, he got a call from Greting Armarak and told him that as per planned, the kidnapping will take place tomorrow and he should come. Sengsang K. Sangma told Greting Armarak to fetch him from village Damas East Garo Hills. Accordingly, Gautam Basumatari and Greting Armarak went and fetched him from a motorbike and they spent a night in the jungle Mzonga. Next morning, Sengsang K. Sangma, Greting Armarak and Gautam Basumatari came to the house of Gautam Basumatari at Kachua Bazaar. After some times, a person by the name of Jinku Marak of William Nagar arrived at the house of Gautam Basumatari in a motorbike. At 10 to 11 am, Greting Armarak received a call from Anthony G. Momin that they have bought the kidnapped person and have reached Mzonga. Greting Armarak directed Sengsang K. Sangma and Gautam Basumatari to pick the kidnapped person. So Sengsang Sangma and Gautam Basumatari rode 2 motorbikes, one each, and went towards the place where the kidnapped person was kept. On reaching the said place, Mzonga, the arrested accused Sengsang K. Sangma found that the victim Prem D. Sangma was enticed by Ajay and Sangma and Anthony G. Momin and brought at Mzonga without any suspicion. Then Anthony G. Momin took a ride with Sengsang K. Sangma and Ajay and Sangma, and the victim Prem D. Sangma took a ride with Gautam Basumatari. As per the instruction from the Greting Armarak, they took the victim towards reserve forest at Borjar Garopada, where Greting Armarak, Jhinku Armarak and Loverson Basumatari were already waiting there. As soon as they arrived the said place, the victim Prem D. Sangma was handed over to Greting Armarak and they took him to the reserve forest and kept there. Then Sengsang K. Sangma and Gautam Basumatari returned to their home. Next day, Sengsang K. Sangma joined the group and he was told by Greting Armarak that one more person will be joining them and his name is Madan Marak. After a while, before getting dark, Madan Marak arrived. They keep on changing the location of the victim in order to avoid detention from the police, and the food was prepared by Akwit Armarak, who is also the brother of Greting Armarak. Next day, Greting Armarak got instruction to Madan Marak and Jhinku Marak to contact the victim's father and demand a sum of 10 lakh for the release of his son. On the day 6 or 7, the final negotiation was done by Jhinku Marak and Madan Marak and took the ransom amount of 3 lakhs with the promise to release the victim, Prem D. Sangma. However, the arrested accused Sengsang Sangma already knew before that the victim will not be released after the ransom, as they were kidnapped by Ajay Sangma and Anthony G. Momin, who was supposedly from the same village as Ajay and Sangma, and Anthony G. Momin kept on telling Greting Armarak not to release the victim Prem D. Sangma. If the victim released, they will be in trouble. So the victim Prem D. Sangma was killed and thrown in the reserve forest. But the arrested accused Sengsang K. Sangma do not know who killed Prem D. Sangma, as he just heard the sound of the firing as their arms were held by Greting Armarak and he was little bit far away from the point of time. The arrested accused Sengsang K. Sangma, after receiving the amount of 35,000, he left the village. Later, he went and surrendered himself with the Assam police. Next day, on 11/1/2016, on leading of the arrested accused and Sengsang K. Sangma, who is in police custody, a raid was conducted at the village Tilapada, Munapada, Borjar Garopada and Boromatia, which falls under Gwalpara district, to effect the arrest of the co-accused Greting R. Marak, Anthony G. Momin, Madan Marak, Jinku Marak, Gautam Basumatari, and 6 Lavasan Daimeri, but no result. After completion of the investigation, I found that there is a case made out against the accused Acquit R. Marak, accused Ajay and Sangma, and accused Sengsang Ke Sangma. 2 of the accused persons are present in the court. They are accused and Sangma and Acquit R. Marak. This is the chief, my lord. In this cross-examination, the investigating officer has stated, my lord, that I have sent the accused before the recording magistrate to record their statement under section 164, but they declined before the magistrate. During my investigation, I have learned that the victim went along with the accused Ajay and Sangma. It is a fact that no force was applied on the victim to go along with the accused Ajay Sangma. It is not a fact that the entire incident took place in Assam. It is a fact that the mobile handset bearing number so and so from the possession of the Ajay and Sangma is not the same mobile number which the accused made phone call to the father of the victim. It is also a fact that the ransom call for money was made by mobile number so and so. It is also a fact that the customer application form of mobile number so and so is in the name of Srimati Payal Mahato. No statement has been taken from Krishnai police station. It is a fact that both the witnesses are police personnel. I have not arrested any person from the Airtel company to establish the fact that the SIM card so and so was a black SIM card. The statement of the accused Ajay and Sangma was entered in the GD entry of Krishnai police station, and I have taken the copy of the said GD. It is a fact that I have not made seizure of any incriminating article with which the victim was killed. I have not taken any disclosure statement of any accused person to prove the fact that the accused have led the police personnel. No flesh was there when I took photograph, and only the skull dismembered from the body. No witnesses have appended the signature in the photographs. The photograph was taken in a mobile, so photograph cannot be developed in jungle to get the signature of the witnesses in the photographs. I have not sent the clothes of the deceased for forensic laboratory science examination. I have not seized the clothes of the deceased. It is a fact that I have not seized any vehicle. It is also a fact that I have not seized the SIM card number so and so. It is a fact that I have not made the sister of the victim, Miss So and so, as witness. There were certain questions put before by the court also, my lord. The mobile number so and so thought it was found to be registered in the name of Payal Mahato, but as per CDR, it shows that the said number was within the vicinity of the place of occurrence. I have sent the WT message to OC Dimapur, PS so and so, to trace out Payal Mahato and to intimate me, but there was no reply from Dimapur police till charge sheet. I could not record the statement of Rani D. Sangma, sister of the victim, as they were still in shock, and also her mother did not allow her to be involved during the investigation. This is the chief and cross-examination of the investigating officer of the case, my lord.
Yes.
Yes. My lord, here it is still not clear who had killed the victim, my lord. No murder weapon was seized, my lord. My lord, though I had a mobile with me which was seized, my lord, the location was never traced or made to be traced within the vicinity of the crime, or my presence was detected there, my lord. Second part, my lord, the only witness, not witness, my lord, the sister of the victim who had seen me to have been going out with the victim, my lord, she was never brought before the court or her statement was recorded. The person who had seen me going talks about of a small boy, my lord. My lord, the time period between my last scene and the recovery of the dead body is about 15 days, my lord. My lord, the body recovered was identified by the clothes of the victim which he was wearing last was by the father. But no superimposition test was done, my lord. No DNA was conducted to ascertain that the body was actually belonged to the victim, my lord. No disclosure was recorded, my lord, at the police station. Father says that I led to the recovery of the body. Police says the other appellant led us to the body, my lord, in the charge sheet. Investigating officer says mothers came out of the house out of curiosity and saw me talking to the victim, whereas in a deposition the mother completely silent, my lord, on that. My lord, there is no corroboration of all the witnesses which nails me, my lord.
Yes.
My lord, all the other criminals, the person charge sheeted were all dreaded criminals belonging to the banned organization, my lord. And Acquit R. Marak, my lord, he says that he was threatened to cook food for them. My lord, now I may take to lordship, my lord. A judgment of the Apex Court, my lord, we spoke about the superimposition test, my lord. My lord, it is AIR 2022 SCC 5535. My lord, it is K. Kalishwaran versus State by the Investigating Police, Tamil Nadu, my lord. My lord, here it is the same 302 case, my lord. If you read the head note, my lord, at
What
C.
is the proposition for which you cite?
My lord, that's
What is the proposition for which you cite?
superimposition test, my lord.
Superimposition?
Test, my lord. At the time of the recovery of the body. My lord, it says at C, my lord. D, my lord, I beg to differ. D. When dead body of the deceased was discovered from place shown by accused, it is imperative on the part of the prosecution that dead body or skeleton found at the instance of the accused was that of the victim and of none else. Skeletal remains of deceased were found after almost 5 months from the date of incident of deceased went business.
And here, when was the thing found?
On 3rd of November, my lord. 3rd November, my lord. 2015, my lord. My lord, it further says identification of dead body was done by getting the skull superimposition test done through forensic expert. Superimposition report was not supported by any other reliable medical evidence like a DNA report or post-mortem report. It would be very risky to convict the accused believing the identification of dead body of deceased through superimposition test. Next part, E, my lord. Accused persons allegedly in furtherance of conspiracy hatched by them murdered the taxi driver. Thereafter buried his dead body and sold out his car, and they shared sale proceeds of the car. Prosecution failed to prove motive of accused person for committing alleged crime. Persons to whom car of deceased was allegedly sold by the accused person had turned hostile. He did not support the case of the prosecution that money was received by accused person by selling car of the deceased. Chain of circumstances was not complete to establish guilt of accused person. Conviction set aside. Now, my lord, here superimposition test was done, my lord. But in my case, that test was also not done, my lord. Then I take, my lord, to another judgment from the Apex Court, my lord. The citation is AIR 20-2023, Supreme Court 634, Munna Lal versus State of Uttar Pradesh.
Make copies of this.
My lord, may kindly come to paragraph 40 at page 642. Paragraph 42, my lord, at page number 642, my lord.
Paragraph 42.
For paragraph 42 at page 642, my lord.
What is the proposition for which you're citing?
Proposition, my lord. I may be allowed to read it, my lord. Although mere defects in the investigative process by itself cannot constitute ground for acquittal, it is the legal obligation of the court to examine carefully. In each case, the prosecution evidence dehoards the lapses committed by the investigating officer to find out whether the evidence brought on record is at all reliable and whether such lapses affect the object of finding out the truth. Being conscious of the above position in law and to avoid erosion of the faith and confidence of the people in the administration of criminal justice, this court has examined the evidence led by the prosecution threadbare and refrained from giving primacy to the negligence of the investigating officer as well as to the omission or lapses resulting from the perfunctory investigation undertaken by him. The endeavor of this court has been to reach the root of the matter by analyzing and assessing the evidence on record and to ascertain whether the appellants were duly found to be guilty as well as to ensure that the guilty does not escape the rigors of law. The disturbing feature in the process of investigation since notice have not waited in the court's mind to give the benefit of doubt to the appellant, but on proper evaluation of the various facts and circumstances, it has transpired that there were reasons for which PW2 might have falsely implicated the appellants and also that PW3 was not wholly reliable witness. There is a fair degree of uncertainty in the prosecution story and the courts below appear to have somehow been influenced by the oral testimony of PW2 and PW3 without taking into consideration the effect of other attending circumstances, thereby warranting interference.
Doesn't here, neither here nor there. Neither here nor there.
But then there is another judgment from Apex Court, my lord. It is somewhat an observation. My lord, this is 2022 Live Law SC 926. It is Rahul versus State of Delhi. It's slightly different, my lord. It talks about death penalty in the second paragraph of the first page, my lord, at the head note. It may be true that if the accused involved in the heinous crime go unpunished or are acquitted, a kind of agony and frustration may be caused to the society in general and to the family of the victim in particular. However, the law does not permit the courts to punish the accused on the basis of moral conviction or on suspicion alone. No conviction should be based merely on the apprehension of indictment of condemnation over the decision rendered. Every case has to be decided by the court strictly on merit and in accordance with the law without being influenced by any kind of outside moral pressure. In order to sustain conviction, the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability the crime was committed by the accused only and none else. The circumstantial evidence must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused, and such evidence should not only be consistent with the guilt of the accused but should be inconsistent with his innocence. My lord, then I have two other judgments which are of recent, my lord. This was decided by the Apex Court on 18th May 2023, my lord. It is Ravi Mandal versus State of Uttarakhand. My lord, may kindly
Find out if this is reported anywhere. Give us the neutral citation.
My lord,
Give us the neutral citation.
Lord, this has not come out so far. It has not been reported in the AIR or SEC so far, my lord.
Wherever it must be on the Supreme Court website.
Website, my lord.
So therefore, the neutral citation will be there.
I will, my lord. I'll provide it. My lord, the point I wish to bring before your lordship.
What is the proposition for which you cite this?
My lord, the thing is that
you read the judgment, thought it was good.
No.
That's why, like the other ones.
The conclusion, my lord.
No, none of them have any application. They're general sentences. What is you cite a judgment for a proposition of law. What is the proposition of law for which you're citing this judgment?
My lord, I'm taking to your lordship.
Tell us the proposition. You take us wherever you want to.
Section 27, my lord. There's a recent judgment which.
What is the proposition for which you're citing the judgment?
That it was not complied, my lord. My lord, the statement of the accused ought to be recorded by the investigating
officer. So non-compliance of section 27.
Section 27, my lord. It is very clear, my lord.
Very well. Where is it?
It is, my lord. Again, it is, my lord. I apologize, my lord. I got it from the website. It is at Bobby versus State of Kerala.
No. This judgment.
No, there's nothing.
Shabir.
Only that part is that, my lord.
What part is there?
My lord, the concluding part at page 35, my lord. The conclusion, my lord. In the light of the discussion above, my lord, it again speaks about the circumstantial evidence, my lord. My lord, then the recent judgment of Bobby versus State of Kerala, my lord.
Give us neutral citations of all this.
I will, my lord. My lord, it deals extensively with section 27 of the Indian Evidence Act.
Yes.
The non-recording of the statement.
Yes, where are you?
My lord, at page 10, the first. Paragraph 9, my lord. These are the observations, my lord, about this circumstantial evidence. First, I take to that, my lord. Do I read it, my lord?
Yes, of course. You're citing it on section 27, you're going on to circumstantial evidence.
It follows the section 27 also, my lord. Kindly bear with me, my lord. Undisputedly, the present case rests entirely on circumstantial evidence. A 3-judges bench of this court in the case of Sharad Birdichand Sharda versus State of Maharashtra had laid down the golden principles with regard to conviction in a case which rests entirely on circumstantial evidence. We may gainfully refer to the following observations of this court in the said case. A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. Number 1, the circumstances with which the conclusion of the guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji Shabrao Babde versus State of Maharashtra. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is a long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. Number 4, they should exclude every possible hypothesis except the one to be proved. And 5, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. My lord, the same judgment also speak about the last sin theory, my lord. And thereafter, my lord, at page 17, section 27, my lord.
Paragraph.
My lord, page 16, paragraph 20, my lord. Page 16, paragraph 20, my lord. As early as 1946, the Privy Council has considered the provisions of section 27. Of the Evidence Act in the case of Pulukuri, Potaya and others versus King Emperor. It will be relevant to refer to the following observations of the Privy Council in the said case. The second question, which involves the construction of section 27 of the Evidence Act, will now be considered. That section and the two preceding sections with which it must be read are in these terms. Section 27, which is not artistically worded, provides an exception to the prohibition imposed by the preceding section and enables certain statement made by a person in police custody to be proved. The condition necessary to bring this section into operation is that the discovery of a fact in consequence of information received from a person accused of any offence in the custody of a police officer must be deposed to, and thereupon so much of the information as relates distinctly to the fact thereby discovered may be proved. The section seems to be based on the view that if a fact is actually discovered in consequence of information given, some guarantee is afforded thereby that the information was true, and accordingly can be safely allowed to be given in evidence. But clearly the extent of the information admissible must depend on the exact nature of the fact discovered to which such information is required to relate. Normally, the section is brought into operation when a person is in police custody, produces from some place of concealment some object such as a dead body, a weapon or ornament said to be connected with the crime of which the informant is accused. Mr. Megao for the Crown has argued that in such a case, the fact discovered is the physical object produced, and that any information which relates distinctly to that object can be proved. On this view, information given by a person that the body produced is that of a person murdered by him, that the weapon produced is one used by him in the commission of the murder, or that the ornaments produced were stolen in a dacoity would all be admissible. If this be the effect of section 27, little substance will remain in the ban imposed by the two preceding sections on confessions made to the police or by persons in police custody. That ban was presumably inspired by the fear of the legislature that a person under police influence might be induced to confess by the exercise of undue pressure. But if all that is required to lift the ban be the inclusion in the confession of information relating to an object subsequently produced, it seems reasonable to suppose that persuasive power of the police will prove equal to the occasion, and that in practice the ban will lose its effect. On normal principles of construction, their lordships think that the proviso to section 26 added by section 27 should not be held to nullify the substance of the section. In their lordships' view, it is fallacious to treat the fact discovered within this section as equivalent to the object produced. The fact discovered embraces the place from which the object is produced and the knowledge of the accused as to this, and the information given must relate distinctly to this fact. Information as to the past user or the past history of the object produced is not related to its discovery in the setting which is discovered. Information supplied by a person in custody that I will produce a knife concealed in the roof of my house does not lead to the discovery of a knife. Knives were discovered many years ago. It leads to the discovery of the fact that knife is concealed in the house, the informant to his knowledge and if the knife is proved to have been used in the commission of the offence, the fact discovered is very relevant. But if to the statement the words be added, with which I stabbed A, these words are inadmissible since they do not relate to the discovery of the knife in the house of the informant. Paragraph 21, my lord. It could thus be seen that Section 27 of the Evidence Act requires that the fact discovered embraces the place from which the object is produced and the knowledge of the accused as to this. And the information given must relate distinctly to the said effect. The information as to past user or the past history of the object produced is not related to the discovery. The said view has been consistently followed by this court in a satina of cases. Now, my lord, again, I take your lordship to paragraph 24, my lord, in which again section 27 has been discussed, my lord. At page 20, my lord. It will be relevant to refer the following observations of this court in the case of State of Karnataka versus David Rosario and another. This information, which is otherwise admissible, becomes inadmissible under section 27 if the information do not come from a person in the custody of a police officer or did not come from the person not in the custody of the police officer. The statement which is admissible under section 27 is the one which is the information leading to discovery. Thus, which is admissible being information, the same has to be proved and not the opinion formed on it by the police officer. In other words, the exact information given by the accused while in custody which led to the recovery of the article has to be proved. It is therefore necessary for the benefit of both the accused and the prosecution that information given should be recorded and proved, and if not so recorded, the exact information must be adduced through evidence. The basic idea embedded in section 27 of the Evidence Act is the doctrine of confirmation by subsequent events. The doctrine is founded on the principle that if any fact is discovered as the search is made on the strength of any information obtained from a prisoner, such a discovery is a guarantee that the information supplied by the prisoner is true. The information might be confessional or non-inculpatory in nature, but if it results in discovery of a fact, it becomes a reliable information. My lord, again speaks about section 27, independent witnesses, at page 22, paragraph 84, my lord. If it is say of the investigating officer that the accused appellant while in custody on his own free will and violation made a statement that he would lead to the place where he had hidden the weapon of offence, the site of burial of the dead body, clothes, etc., then the first thing that the investigating officer should have done was to call for 2 independent witnesses at the police station itself. One of the 2 independent witnesses would arrive at the police station. Thereafter, in their presence, the accused should be asked to make an appropriate statement, as they have desire in regard to pointing out the place where he is said to have hidden the weapon of offence, etc. When the accused while in custody makes such statement before the 2 independent witnesses, punch witnesses, the exact statement, or rather the exact word uttered by the accused, should be incorporated in the first part of the panchnama that the investigating officer may draw in accordance with law. The first part of the panchnama for the purpose of section 27 of the Evidence Act is always drawn at the police station in the presence of independent witnesses, so as to lend credence to that particular statement was made by the accused expressing his willingness on his own free will and violation to point out the place where the weapon of offence or any other article used in the commission of the offence has been hidden. Once the first part of Panchnama is completed, thereafter the police party along with the accused and 2 independent witnesses would proceed to a particular place as may be led by the accused. If from that particular place anything like the weapon of offence or blood-stained clothes or any other article is discovered, then that part of the entire process would form the second part of the Panchnama. This is how the law expects the investigating officer to draw the discovery panchnama as contemplated under section 27 of the Evidence Act. If we read the entire or oral evidence of the investigating officer, then it is clear that the same is deficient in the all aforesaid relevant aspects of the matter. The court has elaborately considered as to how the law expects the investigating officer to draw the discovery panchnama as contemplated under Section 27 of the Evidence Act. In the present case, leave aside the recovery panchnama being in accordance with the aforesaid requirement, there is no statement of Bobby, accused number 3 appellant, herein, recorded under Section 27. We are therefore of the considered view that the prosecution has failed to prove the circumstance that the dead body of the deceased was recovered at the instance of the accused person.
Anything else?
No, my lord. I rest my submission, my lord.
We'll hear you some other day. But in the meantime, you give us the neutral citations
My
on
lord.
these.
I will try to find it out, my lord. Well, my friend is arguing in Section 27. There is no quarrel so far as the proposition of law is concerned, my lord. We are not in 27, my lord.
Section 27 was not recorded over here.
My lord.
Where is the evidence adduced as to the statement? Section 27 was not recorded.
My lord.
Section 27 ought to have been recorded in the presence of two independent witnesses.
My lord.
Now, so how do you prove that the accused led you to the body?
My lord, the statement of the IO, my lord, which has not been reverted at any stage.
That's neither here nor there.
But,
That statement of the IO cannot be taken. That's contrary to 25. And such statement of the IO will be accepted, which is in compliance with 27.
my lord,
27 is an exception to 25.
my lord,
You have to look at it that way. 27 is not a standalone.
my lord,
27 is an exception to 25.
my lord.
Whatever the IO says will be hit by 25. But the only thing is that if it leads to a discovery, then of course there can be reliance on the statement. So for that there has to be a statement which is recorded in accordance with 27. And it is possible, even if it is not recorded in accordance with 27, a substantial reproduction of the statement should be adduced in evidence. Where is that?
But Section 27 is not there, my lord, so there is no question. What is not there, I cannot
Section
proceed.
27 is
Now,
not there, the body
My
is
lord,
not
only
there.
thing is that I'll be taking, my lord, the fact that the statement of the complainant, wherein he said that the discovery of the dead body was at the instance of one of the accused. Now, IO statement says there at the instance of both the accused. Now, my lord, coupled with the fact that the accused was last seen together with the victim. Now, that gets a confirmation, my lord, in his reply in 313. Because accused came out with a story that he was also kidnapped with the victim.
And he was shot.
He was shot. And my lord, his jacket, he showed his jacket to be torn, my lord, and then it was seized. And it was sent for forensic examination, nothing was found. He has falsified that. And my lord, there is no rebuttal to it. Now, one thing is that he confirms that he was shot. He confirms in his 313 that on 2710.
Only thing he confirms over there that the victim was with him.
Till on 2710.
Victim was with him. That is what he confirms.
My lord.
So that is something which is there.
My lord.
But taking him to the body, taking you to the body is not there.
My lord, so far as that part of the evidence is concerned, my lord, that they led to the recovery of the body, my lord. My lord, at no point of the trial, my lord, that has been denied, my lord. Whatever evidence has been adduced on behalf of the prosecution, my lord, there is no rebuttal to it. Not at all a single question was put, my lord.
That part he is not required to deny because of 25.
My lord, I will rely on section 8 and I rely on a judgment by your lordship also, my lord. And my lord, so far as the proposition of law is concerned, my lord, when there is a recovery at the instance of the
Res geste does not take away the requirement of 27. Res geste is different, exculpatory, inculpatory is different.
My lord, but the conduct will come under section 8 of the evidence.
Yes, that's res geste.
My lord, I may rely on a decision if lordship permits me.
We'll see when you come
My lord,
back next.
my lord.
When will you give us the neutral citations? Only one judgment that you cite is of relevance, which is this last one. The other judgments are, of course, irrelevant.
The last one is, my lord, I'll give a neutral
Bobby.
citation to it. Bobby.
Not Bobby, Bobby.
Bobby, yes, my lord.
Bobby.
Bobby.
My lord, we actually not received those judgments. So
Yes, you have to give it to them.
No, sir.
Unreported judgments you have to immediately give.
You have to find it out, my lord, sir.
I will give a neutral citation to this, my lord.
The appeal is heard in part and will appear when?
My lord, any date convenient to the court, my lord.
Tell us.
After 4 weeks, my lord.
4 weeks. We would have forgotten everything.
And then it come as and when your
And will
lordship,
appear next week.
next week. Deeply obliged.